But in this next segment, I've got somebody that's going to be talking to you about our constitutional rights, which have been under attack ever since Governor Pritzker, and actually before that, took office. I mean, this is a guy who does not respect any bit of what's constitutional. We're talking about 36 months of COVID shutdown. We're talking about, putting on a speech, compelling speech for pro-life pregnancy centers that they had to refer for abortion. We're talking about shutting down other speech of pro-life pregnancy centers. I mean, it just goes on. And one of the biggest things that he's done is he's tried to get rid of the 2A in the state of Illinois, something that we have long fought for. I remember back as a brand new freshman legislator in 2013, we were under court order at that time by the Seventh Circuit to actually pass concealed carry legislation. We were the last state in the United States to have a concealed carry law. It took us 6 months to do it. Madigan played games with that, but we did get it passed, and now we're back at it again. And this particular one is the gun ban law. And it's been, it's been back and forth between state courts and federal courts. And just recently, Judge McGlynn ruled that the Protect Illinois Communities Act, that's what they call it. Oh, my gosh. I mean, they just make up just the most ridiculous names for some of these laws. It's not true. You're not protecting Illinois communities with this. You're banning legal weapons from legal gun owners. That's what you're doing. But anyway, McGlynn ruled that PICA infringes on an individual's Second Amendment rights, citing the recent U.S. Supreme Court interpretations of the Second Amendment. He stated the government may not deprive law-abiding citizens of their guaranteed right to self-defense as a means of offense. The decision further stated there are those who seek to usher in a sort of post-Constitution era where the citizens' individual rights are only as important as they are convenient to a ruling class. Oh, my gosh. Like, put that on a billboard and then put Governor Pritzker's name next to it, because that's exactly what he's been doing since he's been governing. But here to talk about that more is somebody who knows far more about this legislation than I do. It is Dan Eldridge. He is the owner of Maxon Shooters, which is up, I believe, in Des Plaines, Illinois. He's been following the case closely. I think he's actually a party to the case, or at least he's donated to it. And he's going to explain it all to us because he's here calling in, I think, from Florida. Dan, thanks so much for being on my show. I really appreciate you taking time with us tonight.
Hi, Jeanne. Glad to be here. This was a big win. This was 168 pages of win and a record that's going to really present a problem for the state.
Okay, so start from the beginning, because I think I am right? This bill, this legislation, the gun ban law, how it's commonly referred to, it got challenged in both the state court and the federal court. It sort of ran its course through the state courts, and of course, with our state Supreme Court being controlled by Democrats, it was completely found to be constitutional. And so now the federal cases have been winding them through. I believe there's one in the Southern District and both the Northern District. Can you just kind of give us a lay of the land of where all these cases stand?
Well, first of all, it started with one of these gut and replace operations by the Illinois General Assembly in January of 2023, where they took a completely unrelated bill and pasted in all of this gun control stuff and assault weapon bans, which appear to have just been a cut and paste from other states' so-called assault weapon bans. So that was January of last year, and we immediately organized with Federal Firearms Licensees of Illinois, which is the Dealers Association, and the Aurora Sportsman's Club formed a 501c3, and with just a complete grassroots effort to fight this thing. We have member plaintiffs in the Southern District. We filed suit in the Southern District and were granted a preliminary injunction by Judge Stephen McGlynn. That would be back in April of last year. The cases that were pursued in the Northern District faced a different set of judges who found against their motions for preliminary injunction. So you had a split. The state cases, the state court cases, a lot of them got bounced up to federal court because this really is a 2A issue. So we won. We had what we called Freedom Week, where the clock was reset to January 9th in terms of what you could buy and transfer. And that was foreclosed by the state and the Seventh Circuit Court of Appeals when the state filed for an emergency stay on our injunction, meaning our injunction would not be enforced on an emergency basis. Mm-hmm. That summer, we then had, I'm sorry, not that summer. I guess it would be this summer. No, last summer. Yeah. Mm-hmm. Last year. It's shocking that this is almost 2 years into this. We had the trial in the Seventh Circuit with a very unfriendly panel. And just to be clear, the trial last summer was all about preliminary motions and preliminary maneuvering. Basically, were we going to be able to continue business as usual while this issue was litigated, which really would have been proper. That's why you would normally seek and be granted an injunction, because you reset the clock. If a statute is challenged, you stay enforcement of that until it gets sorted out in court. Well, we didn't get there. What we did get from the Seventh Circuit when we finally had the orals was just a dog's breakfast of interest balancing and nonsense from two of the three judges. That would be Frank Easterbrook and Diane Wood. The Supreme Court told them, or the Supreme Court told all of the circuit courts in the Bruin decision in 2022 that the only relevant tests here, there are two tests. One test, are these items in common use for lawful purposes? And any regulation has to be consistent with the text, history, and tradition in this country. That is it, full stop. Judge Easterbrook and Woods then invented their own test because they're, I guess, smarter than the Supreme Court is. And their test was, well, if it's got military applications, it can be banned. Or if it looks like something that has military applications, it can be banned. Well, that's not what your bosses told you to do, but they did it anyway. Fine. So we get bounced back down to the district court, and we have our trial back, I believe it was in September. Jeanne, we came better prepared. There's no other way to put it. We came prepared to attack this on the Bruin and Heller standard, and we came prepared to attack it on Easterbrook's nonsensical interest balancing. It looks like a military gun, therefore it can be banned. And we succeeded in doing that. The state really punted here. And the impression that I get is that they just planned on taking the loss and trying to prevail in the seventh. Well, they got a little problem there now because Judge Wood resigned from the bench last summer. So right now, that three-judge panel is a two-judge panel and split 50-50. Additionally, they're going to have to saw their way through 168 pages of really substantial stuff that Judge McGlynn put together. And depending on how this panel is formed, whether it's a completely fresh panel or if they add somebody, one of the other judges, I believe there are 11 judges on the Seventh Circuit, we'll have a trial, and we'll have a trial probably early first quarter of next year.
Okay, and so you'll have a trial at the Seventh Circuit Court?
Correct, because what Judge McGlynn's decision is, this is unconstitutional under the Second and 14th Amendment.
Could it stop right now, though, if let's just say Kwame Raoul and Governor Pritzker said we're not going to appeal it? Could it stop right now and they just accept McGlynn's decision? Is that an option?
Well, it's an option. It doesn't seem likely, considering they had their motion for appeal queued up for I mean, that was filed almost immediately after McGlynn's decision. It was filed that evening.
Because part of the argument here is, of course, that they're just wasting time and money to take this out to the nth degree, and more likely than not, it'll be decided, you think, eventually in your favor, whether it's at the Seventh Circuit or even if you had to go to the Supreme Court, because you've got various decisions in different circuits. Is that correct?
We've got multiple paths to victory here. Okay. And I just don't see a path that ends up in victory for the state. And so, yes, if they were being prudent stewards of the taxpayer resources, they would drop it and they would say, okay, I read the 168 pages. He's right. We're wrong. Let's move on. But that's not the way that they are. You can hear it from the statements that they make, where they're dismissive of McGlynn's work. And I think they're doing that at their own peril. So here are the paths that we've got in front of us. A new panel heard the Viramontes case, which is the Cook County assault weapon ban, last week. I don't know what's going to happen with that. It may get bounced back down to the district court because it has a very thin record, that Cook County assault weapon ban case. But should the 7th decide that that needs to get tossed, that's going to make it very hard for any 3-judge panel to permanently enjoin Judge McGlynn, or to throw out Judge McGlynn's decision. Right? If you have a decision out of the 7th Circuit that says the assault weapon ban is unconstitutional, that's path number one. Path number two is the U.S. Supreme Court is waiting on the state, and I believe the last deadline is early January, for the state of Maryland in the Snope case, which is Maryland's assault weapon ban. That one's been all the way up to the Supreme Court before. It was granted cert, vacated, and remanded back to the 4th Circuit, and they sat on it for a year, and there was all sorts of shenanigans with that. And so that's a very strong appeal to go back to the Supreme Court. The other side is very quick to point out that the Supreme Court rejected hearing any of our cases. And, yes, that's technically true, but it's also unsurprising because the U.S. Supreme Court is very, very reticent in wanting to hear what's called an interlocutory appeal, something that's still in process. It hasn't had a finding of fact in the trial court. These were all arguing over motions for temporary injunctions and all the rest of that. So it's really not a big surprise. I think that when Clarence Thomas said that he very much looked forward to getting a bite at that 7th Circuit apple in the Easterbrook and Wood decision, that sends a pretty strong message, which is they're looking for one of these to take. The Maryland case is pretty well developed, so there's a high likelihood that they'll grant cert for Maryland. They'll hear it this term, and there will be a decision June, July of next year. All right. If they find for Maryland, all of these assault weapon bans go away.
Well, that's great
So-called
news.
assault weapon bans. I had to be careful.
So in the meantime, where can people help you out? Is there a place where they can donate for the legal defense here and to protect our constitutional rights?
Well, thanks for asking. Yeah, the website for the Dealers Association is fflil.org. That's Federal Firearms Licensees of Illinois.org. And we appreciate the support. It's been tremendous so far. The organization has raised several $100,000s of dollars for this effort. And let me tell you, it is astonishingly expensive to be involved in suits in federal court. So,
well, that's the other thing that they do, Dan. That's the other thing they want to do. They want to wait you out. They want to make it so cost prohibitive that you never sue. They take away your rights in the state of Illinois, and then they force you to sue to get them back. That's what they do. They need to be put out of office. They are un-American to their core. We got to leave it right there, Dan. I want to thank you so much, Dan Eldridge, Maxon Shooters. He's got a great operation there. If you're looking for a firearm, I suggest you go there. If you're looking for range time, go there as well. Dan, thanks so much for having us on, coming on my show. fflil.org is where you can donate to this case. Thanks a lot, Dan.
Thank you, Jeanne.